With the Dobbs decision overturning Roe v. Wade last summer, the Supreme Court returned the issue of abortion to policymakers from whom they seized the issue 50 years ago. Though the states once again have the opportunity to uphold the sanctity of human life, something I did at the state level and was challenged in court, well, the court has also opened the door for federal legislation to protect unborn babies. It's not like this is just for the states, but some pro-life national legislators have raised concerns that any federal legislation that might be passed, such as Senator Lindsey Graham's proposed pain-capable legislation, at 15 weeks when a baby's sucking their thumb, would pose legal challenges for stronger legislation at the state level and somehow should be off the table. Well, I must have missed that in my 30 years, and my time in the pro-life movement actively involved was almost 30 years to the date of the overturn of Roe v. Wade. I never heard legislators here in Washington, D.C. saying this was a state's issue. I mean, the Republican Party platform attempted to pass or called for a human rights amendment. That's federal, has to be approved by the states, but it starts out here. So where'd this come from? Joining me now to help clear up any confusion from a legal perspective is Ken Klukowski, former senior counsel in the Civil Rights Division of the U.S. Department of Justice and former special counsel in the White House Office of Management and Budget. He's also litigated constitutional cases before the U.S. Supreme Court. Ken, welcome back to Washington Watch. Good to see you.
Always great to be with you, Tony. Thanks for having me.
So the Supreme Court decision, unlike what the left would like to say, did not ban abortion. It simply returned the issue to policymakers. That includes those at the state level. But that doesn't mean this is only an issue for the states. Or did I miss something?
You're exactly right on that, Tony. It's, as you know, having been a state legislator yourself, we have a federal system in this country. You have federal lawmakers in Congress, and you have state lawmakers in the 50 state legislatures across the country. Now, when it comes to issues of public health, public safety, personal responsibility and morality, and general social welfare, those are the four headings of what we call the police power. And that's something that state governments have. Again, you would have voted on many of those laws yourself. But then you do have the various powers of Congress under Article 1, Section 8 of the U.S. Constitution. And there are a number of those federal powers that would also have to do with abortion. They're different, and states, I think, certainly between the two have more of the leading role. But there's a role both for state governments, for state lawmakers, and for federal lawmakers, all of them answerable to the voters when it comes to the issue of abortion. And the Supreme Court's decision in Dobbs is perfectly consistent with that.
Right, so let me ask you a question about the Dobbs decision. Was there something in there I missed, tucked away, that said we now turn this back over to the states and only state legislators have a policy role in the issue of abortion?
Not at all. In fact, Justice Alito, writing for the court, said that they were turning the matter over to elected lawmakers, people who would answer to the voters. And again, that could be your state senator, or it could be one of your two U.S. senators in Washington, D.C.
So I agree with you from a standpoint of, I think running point on this issue are state legislators. In fact, we wouldn't be having this discussion if it were not for state legislators willing to push the envelope and advance the sanctity of human life. And we've seen that over the last decade, really since 2010 is when we saw this aggressive push at the state levels after we saw Republicans take control of so many state legislative bodies. But I want to match the rhetoric that we're hearing here in Washington, D.C., out of actually some of our conservative friends who are pro-life. I don't question their pro-life credentials. But all of a sudden, these same ones who were advocating for a 20-week bill, they voted for it, which was at the time the science said that's when the pain was experienced. Those that have rightfully been defending the limitation on government funding of abortion, the Hyde Amendment. But now all of a sudden they've lost their, their fight for this issue, and they're moving it, saying it's all about the states. It's not adding up to me.
Well, I'll tell you, Tony, many of our viewers would be familiar with anyone in business, anyone who's part of a large commercial enterprise knows that you've got federal laws and you've got state laws. And many of those things overlap. You have state employment laws, you have federal employment laws. When it comes to something like highway funding, for example, a lot of highway money comes from the states, but there can also be federal grants, and then the federal government can attach conditions for that grant. So if your state says no roads in this state are going to have a speed limit over 70 miles an hour, but then if Congress says, but if you want to get federal money for your roads, no one can go over 65 miles per hour.
And they've done
well,
that.
if you want to get that money, you're going to have to live by both sets of laws.
And they've done that. And they do that all the time.
Right.
They do that all the time. Ken Klukowski, we're out of time, but I thank you for joining us and clearing that up, that there was nothing in the Dobbs decision saying that this was a states-only issue. Good to see you.
Thank you. You too. God bless.